Okay, Judge.
Thank you.
You're welcome.
Ms. Heatherall, this first document I'm showing you, you notice that at the top it's got what I call identifying information. First of all, it's case number 646514. That is charge against you, the state of Texas versus Lauren Carol Heatherall. Or yes, in County Court of Law number 5, Bexar County, Texas. That'll be repeated on all the different documents with one exception. The title of this document is State's Consent to Video Conference. As I mentioned a while ago, both you and the state have the right to demand an open public courtroom hearing. This document is signed by Ms. Caitlin Morgan, who is acting for the district attorney's office. She has agreed to the video conference. Did you see and understand that first document?
Yes, Your Honor.
All right, this next one is called a discovery acknowledgement. Again, a repetition of the identifying information. The particular document titled in this case is discovery acknowledgement. By the way, the titles are all in all capitals, bold print. This one says discovery acknowledgement. You'll notice the first line says pursuant to Article 39.14 of the Code of Criminal Procedure. That is a law in Texas that requires that the state of Texas, the prosecutors, share, acknowledge, and disclose to you and your attorney all the information, documents, receipts, books, whatever that apply to your case so that you and your attorney can make a fully informed and intelligent decision. This one is signed by your attorney and the state's attorney saying, yes, this law has been obeyed. Did you see and understand that?
Yes, Your Honor.
This next document, again with identifying information, it says, the title rather is Defendant's Consent to Video Conference. That's yours. You understand you agreed to the video conference and not demand that this be in the open public courtroom.
Yes, Your Honor.
All right. All of these will be part of the record. Now, this next document with identifying information, repetition, this one is titled Defendant's Waiver of Constitutional Rights and Court's Admonitions. It starts off with 3 individual sentences, then the rest of it is essentially divided into 15 substantial parts that are numbered individually. The first 3 sentences talk about what that I don't need to read to you, the document that charges you. The second one is DWI with blood alcohol content of 0.15 or higher. That's what the original charge is. You understand that's what it is. The third sentence, what does it say?
What?
In this cause?
I don't think it's scrolled. I
Right there, there's 3 individual sentences. The third one, what does it say? Do you see it? In this cause?
Oh, yes. I enter a plea of no contest to the DUI in the first.
DWI first.
Yes.
All right. Now, the rest of it is divided into numbered sections. The first number is in reference to what the punishment is for the charge that you're pleading to. The DWI first, you can be punished by a fine from $0 to $2,000 and jail from 72 hours to 180 days in jail. Did you see and understand that?
Yes, Your Honor.
Now, Mr. LaWarren, did you assist and guide your client and have closely read and review these documents, and in particular, this document is divided into 15 numbered sections or parts?
I did, Your Honor.
And are you telling me as an officer of the court that you believe that she is fully aware of the documents and the contents?
Yes, Your Honor.
All right. Ms. Heatherall, for the record, where were you born, ma'am?
San Antonio, Texas.
All right. All the documents in the record will reflect that you are a U.S. citizen. And another thing of significance, particular significance, is it is important that you understand that the agreement that you have made with the state is not necessarily, is not it is not demanded that I follow it. That's a very wordy and improper way of saying the court must decide whether I accept your deal or reject it. I can also give you any punishment in the range of punishment applicable to DWI first, even if the punishment is heavier than what you agreed to. However, if I reject your deal, or if I give you a punishment greater than what you've agreed to, in that case, the law would allow you to start all over again, and nothing that you said or signed would be used against you. Is that clear, ma'am?
Yes, Your Honor.
You reviewed this document, you have signed it, and so has your attorney. Is that correct?
Yes, Your Honor.
The state has signed it, and I have signed it. I do approve the agreement. This document in front of you now, again with the identifying information, this is my certification to you regarding the right of appeal. There's a vertical stack of little boxes. Each one has a specific statement concerning the right of appeal. The fifth one is marked. It says that I, as a judge, certify that this is a plea bargain case and the defendant has no right of appeal. Is that understood?
Yes, Your Honor.
I have signed it, you have signed it, your attorney has signed it. Now, I have before me, again, with the identifying information, an application for deferred adjudication. This is a particularly important agreement that you are making with the court. Did you carefully review this application and understand what you're telling me under oath by signing this document?
Yes, Your Honor.
I want to review this with you briefly because it is critically important. Your attorney has made a very significant and beneficial agreement on your behalf. That agreement is that you, despite the fact that you're pleading nolo contendere, which the court takes as a guilty plea, I will point out that a nolo contendere plea is sufficient for me to convict you, to find you guilty and convict you. But your attorney has made an agreement that I will not find you guilty at this point. It will be deferred. In other words, it'll be postponed. If you live up to 100%, and please listen carefully, if you live up to 100% of the conditions of supervision, then the case will be dismissed and you're not convicted of this charge. It will not carry in Texas, it will not be considered a conviction. Now, obviously then there's an opposite. And first, let me say this, the conditions of supervision will be read to you carefully by a probation officer. You will sign them and a copy will be placed in your hands. If you fail or refuse to live up to 100% of those conditions, then the state will ask me to give you official notice, bring you in for a hearing, at which time there can be a final conviction made at that point, a finding of guilt and a conviction that will carry the rest of your life, unless you're real good pals with the governor and he gives you a pardon. Not very likely, but it can happen. But basically, do you understand that further that if that happens, you're looking at 100% of the punishment range, $0 to $2,000, and jail, 0 to 180 days. Is that very clear, ma'am?
Yes, Your Honor.
All right. You signed this, so did your attorney. The court has approved it. Now, I don't know, did you fill out this personal data sheet, ma'am?
I have a copy. I have it filled out on
Okay.
my computer.
I'm requiring that you submit a filled out copy.
Sure.
Who is your employer?
Baylor Scott and White Hospital.
Okay. And what is your income at Baylor Scott and White?
of 54,000.
Okay. I need you to fill all that out for me, please. You're a full-time employee, I'm sure.
Yes, sir.
All right. I'll need the 3 references that of people that will always be able to find you.
Okay.
Have you served in the military?
No, sir.
Okay. And are you married, single, or divorced?
I'm married.
All right. Children, dependents?
Yes, we have a 2-week-old.
Oh, how wonderful. Okay. And I'm sure you have an automobile. All of that information has to be filled out completely.
Yes, sir.
All right. Now I'm going to try and seek out the rest of these papers because the next one is what's called a plea agreement, the deal.